Hello. Welcome to the Seniors Real Estate and Services video series. I'm Sandra Roman. I'm a real estate agent with Keller Williams Points North, and today I'm with Denise Lanzarone. How are you, Denise? I haven't seen
Yeah. We spent the whole day together, but yes. I'm good, Sandra. Yeah, hi, I'm Denise Lanzarone with Keller Williams as well. I am a senior real estate specialist, which means I have a specific training in helping seniors with their real estate needs or whatever else they need. I have a lot of experience in the healthcare field, a lot of contacts, people that I know because I worked in the healthcare field for many, many years. So we put this series together to provide information and just resources for any seniors out there that are interested. We found that there's a lot of information and resources out there that a lot of people don't know about. So this is just a little service that we're providing, and we hope that you find it helpful. So we have, you can find us on Facebook, Instagram. I'm Denise Lanzarone, your local realtor on Facebook. Instagram, it's just Denise Lanzarone. And Sandra, you can tell them all your places.
My places. Remember, we are live. This is video number four of this second season of us.
Yep.
It's the second season and it's video number 4. We are live every Wednesday, 7 p.m. on Denise's Facebook page. You can find her as Denise Lanzarone. You can see it on my Facebook page and on my YouTube page. On my YouTube channel, you can find me as Sandra Roman Real Estate. Remember, if you're watching me on YouTube, click or ring the bell. Subscribe to my channel. Leave us your comment, and share this information with everybody or with a senior in your life. And what else I was going to say? I totally forgot.
Ring the bell. You forgot ring the bell.
I forgot to ring my bell. And thank you for watching us. And we have a very special guest today. We're going to talk about a very interesting topic. Denise?
Yes, so we have, I actually
hold on. Before, I remember.
What?
We have all the information of all our guests in a PDF file, because I can't say manual because Denise says it sounds weird. We have it on a PDF file. If you want to have this information, we have all our guests from season 1, and we're going to put together all the information of our guests from season number 2. Send us your email. We're going to have a link in the description box below. So leave us your name and your contact information so we can send you that PDF file.
Yeah, it'll be just a good file to have on hand if you ever want to refer back. Say, oh, what was that person's name that did whatever? So it's going to be good. So if you want us to send it, let us know. Okay, before we get any further, want to introduce our guest tonight. I actually attended a estate planning seminar last week that Michelle Dublansky did at one of the assisted living facilities. And she did a great job, and I learned a lot. So we asked her to come on our little show here. So hi, Michelle.
Hello, everyone.
Welcome.
Thank you for having me, Denise and Sandra. I appreciate it.
Well, thanks for coming on.
I also commend you for doing this. It's a nice service to the community. A firm believer in the more you know, the better you do.
Exactly.
So the hope is that I can impart some information to your clients and the community so that they can know more and do better.
Yeah. Because right now we had this event for seniors for Parkinson's awareness, and we were talking with this lady, and she we were talking about Parkinson's and stuff. And she said, well, it's not a lot of information out there. And I'm like, yeah, we couldn't find a lot of information. And sometimes you don't know.
Yeah, yep. You're right. You're right. The more you know, the better you do. And definitely as you get older, one of the most important things you need to consider or prepare for is what happens in the event you require someone, or you no longer have the ability to make medical decisions or healthcare decisions or financial decisions, or what happens when you pass away. That's really, in a nutshell, what estate planning is.
But before I'm going to interrupt you. Where can they find you? Where do you work?
Okay, so my name is Michelle Jablonski, Jablonsky. I am a partner at the law firm of Davidow, Siegel & Stern. We have offices in Islandia and in Mattituck. I have been practicing law now 24 years in June. It seems crazy, but it'll be a long time. It's 24 years. And I've really spent 95% of my time as an attorney in this area of law. And you would think I know all that there is to know, but I do not, because the law is constantly changing. There's a lot of fluidity. There's a lot to know. So gone are the days when, you have the attorney kind of in town who does a little bit of everything. Law is so much more specialized now at this point. But a lot of what we do at the firm is estate planning, elder law planning, special needs trusts and special needs trust planning. That's for individuals or people who have loved ones that have some sort of special needs. And we do a little corporate, although I really don't specialize in that, one or the other. I dabble in it, but one of the other partners really handles that.
And where they can find you?
I am not as technically savvy as Sandra and Denise. I don't have my own Facebook or Instagram page, but the firm does. But we do have a website, and the website is at www.davidowlaw.com, and you spell that DAVIDOWLAW.com.
Okay. Anyway, we're going to put the information on the description, and we're going to have my manual, my PDF file.
That's great.
Explain us what is estate planning.
So let's talk about what estate planning is. There are 3 documents that everyone who is over the age of 18, I am a firm believer, should have. 2 of them we're going to talk about, and when we're talking about these, I'm going to give you some examples so that you can apply it, or you can understand in context what I'm talking about. The first document everyone should have is a healthcare proxy. A healthcare proxy is a document where you give someone the ability to make healthcare decisions for you in the event you can't make healthcare decisions for yourself. As long as you are mentally and physically competent and capable, you remain 100% in charge of your own healthcare decisions. But if at some point you can no longer make those decisions, if you have signed and executed a healthcare proxy, the individual you name in that healthcare proxy will be able to make medical decisions for you. What type of medical decisions
that
can
was
they
going
make
to be
for
my
you?
question. What type of medical decisions?
So that depends on how you draft your healthcare proxy. How we typically draft a healthcare proxy for clients is we have language in the healthcare proxy that says, I have created this healthcare proxy. I have discussed my wishes with my primary agent and also a contingent or a backup agent if the primary agent can't act. And they know my wishes, including my wishes regarding artificial nutrition and hydration. I don't normally put in the healthcare proxy, I never want to be resuscitated. I never want a feeding tube. I never want to be on a ventilator. I like the language that I've appointed someone, they'll make my decisions for me. They know what I want. because then that gives them the ability to take into consideration the totality of the circumstances that exist at the time, and hopefully make the decision you would have made for yourself had you been competent to do so, right?
Yeah.
Medicine is changing just as quickly as technology is changing.
Yes.
They're fighting, and the law is lagging behind all of those things, quite honestly. So there are so many medical situations that could arise that having healthcare proxies with absolutes in them, I don't feel in most cases serves the clients well. However, that does, in that healthcare proxy, the person signing it is saying, I've spoken to the people I'm appointing what I want and telling them what I want and don't want. Those are not easy conversations to have always. A lot of times your agents really don't want to discuss them. So that's why a lot of times we have clients who also sign a backup document called a living will. It's a separate standalone document, and the living will is a document where you express your wishes. It's clear and convincing evidence of your intentions. So if you've named someone in your healthcare proxy, which is the law in New York, that's technically all you need, and a decision needs to be made, and you've never had a discussion with the person you've appointed about what you want and don't want, the living will can serve as a guide. So normally with healthcare decisions, we're recommending clients have healthcare proxy, which is the law in New York, and a living will document that's a separate document, just in case you never get around to having that discussion.
Conversations.
You got it.
Sometimes those conversations are uncomfortable.
They're not easy to have, and when you do have times with your loved ones, you don't want to sit there talking about hard things. You want to have fun, right? Especially when we've been in this COVID piece. So that's why we do it. But obviously, the best situation is to actually have those conversations.
Yeah.
The next document everyone should have is a power of attorney.
Okay.
A power of attorney is a document where you give someone the ability to make financial and business decisions for you while you are alive.
Oh, okay.
Once you pass away, the person you appoint in a power of attorney is no longer able to act for you.
Because you're dead.
You got it. You got it. It's what's known as an advance directive. It only works when you're alive.
Okay.
So in real estate context, sometimes we have elderly clients and their children are their powers of attorney, and they're selling the house using a power of attorney. And if God forbid that person who signed the power of attorney passes away before the closing occurs,
there's a problem.
So that's a little bit of a power of attorney related to the real estate context. A power of attorney, normally the type we recommend is something called a durable general power of attorney. That means it's effective the date you sign it, even when you become incapacitated or incompetent until you pass away.
Okay.
What powers you give the agent you name in the power of attorney and the alternate, because you should have a primary and backups as well.
Yeah, in case something happened to the primary as well.
It happens. We have a lot of clients who come in and say, oh, I have a power of attorney, it's my spouse, and they never name a backup. Well, what if your spouse passes away before you?
Exactly.
Something happens and you never get around to executing a new power of attorney, and you can't. In order to execute any of the documents we're talking about, healthcare proxy, power of attorney, I'm going to talk about a will in a second. The person signing the documents has to be competent.
What competent means?
Well, there's the rub, right? Because how a lot of people are under the mistaken belief that the doctor decides who's competent or not. That is not true.
Who decides?
As a practical matter, the only person who can declare someone incompetent is a judge.
Oh.
And the judge is usually relying on the medical information provided by doctors in conjunction with other things. But a judge is really the only person who can declare someone legally incompetent. So when we have clients that come to the office, that's one of the things that we're doing when we're meeting with them. We're screening them to see if we feel as attorneys that they have legal competency.
Yes.
Legal competency, and it's different for every document. The standard for legal competency for healthcare proxies and living wills is the lowest.
Yes.
Okay. For wills, it's the second lowest, believe it or not.
Oh, really?
To sign a will, you have to know who you are, who the natural objects of your bounty are. Those are your family members, your closest family members, your immediate, family, and what you own and how you own it. And you have to understand who you want to leave your assets to, right? You don't have to be able to do calculus. You don't have to be able to name, A through Z backwards. You don't need to count from 100 back to 1. You don't need, that's not legal competency. Okay. The highest level of competency you need is contractual competency, and a power of attorney is considered a contract, as is a trust. So you don't want to wait until you're getting that diagnosis to have these documents prepared. Exactly. You want to be proactive instead of reactive.
Exactly.
Because if I have a client who needs help managing their financial affairs and they come to the office and I determine that they really don't understand what they're doing, we can't have that power of attorney signed. So now, what does the family member do, right? Mom has an account in her name only. The kids aren't joint on the account.
They can't do anything.
What do they do? Well, they have to petition a court to be appointed as a guardian.
Oh.
And that takes time, costs money. That's the process where a judge will determine if someone no longer has competency to manage their affairs, and they will appoint someone to act in their place. When you have a guardianship, your family members are entitled to participate. Sometimes there's not agreement on who should be acting as the guardian. Yeah. And once a guardian is appointed, they have to account to the court on a yearly basis what is happening with the assets. Again, takes time, costs money. If you know who, and the judge doesn't have to agree with the person asking, right? They could say, none of the kids I don't think are appropriate to act as guardian for mom. I'm going to name an attorney. An independent third party. And that attorney or accountant or financial advisor does not act for free.
No, you have to pay them.
You've got it. So if you want to opt out of that process, you need to make sure you have healthcare proxy, living will, and a power of attorney, because those are the documents that govern what happens to your health, medical condition, and your money and assets while you are alive.
Okay.
Then we shift to the next stage of life.
That you die, and then what happens when you die?
What happens then? So the third document everyone should have is a last will and testament.
How do you do one of those?
So you go to an attorney, and usually what we do is we go over your assets, what you own and how you own it. And then we have a discussion about how you want your assets to pass.
Yeah, because sometimes, you say, wills or testaments are for rich people that has a lot of money. And sometimes if it's only one house and two siblings, then there's a big problem, because you can sell the house and it's money. And then there's a problem between the siblings.
You've got it. So here's the caveat about wills. A lot of people think if you create a will, your will controls everything you own when you die. That is 100% not true.
Ooh.
Your will only controls the assets you own in your name when you pass away, without a surviving joint owner, without a beneficiary, not transferred or titled into a trust, or not transferred via deed by what's known as a life estate deed. So if I die, if everything I own has a joint owner or a beneficiary, or is in a trust, or has been transferred by a life estate deed.
What is a trust?
Let me get to this first, and then we're going to get to the
yes,
trust.
Yes. I'm sorry. I just got questions.
But then my will controls nothing, right?
Oh my goodness.
So when I die, I have a bank account. Let's say I have a will that leaves everything to save the whales.
Mm-hmm.
I love animals. And my sister is the executor of that will. If I have a bank account that's joint with my daughter, who's getting the money in that bank account when I die?
Your daughter.
Exactly, because she's joint on the account.
Mm-hmm.
If I have a life insurance policy that names my son as the beneficiary, who's getting that?
Your son.
You got it. I own a piece of real property. My husband and I are joint on the deed. Who gets the house when I die?
The husband.
He does, because he's on the deed. Okay. But I have 100 shares of Exxon stock that I inherited from my grandmother in the name of Michelle only. Who's getting that stock?
Whoever you want to give it to.
Well, who is in my will, right? My will is going to control where that stock goes.
The whales are getting that one.
The whales are getting that one. How do the whales get it? Does my sister just get to take my original death certificate and my will to ExxonMobil and say, give me the 100 shares of stock, I'm her executor?
It has to go through court?
It has to go through probate.
Oh, probate.
Probate is the process where you prove a will to be true. Oh. So my sister will take my original death certificate, my original will. My husband and my children will sign some paperwork consenting that I was competent when I signed the will, and they believe that is my true last will and testament. And assuming they're all in agreement, my sister will submit all of those documents to the court. Absent any objections from my husband or my children, the judge will review the documentation, and the judge will say or issue what's known as letters testamentary. That's a court order that alerts the rest of the world my sister has been appointed by the court as executor. My sister takes that court order and with other documentation sends it to Exxon to transfer the ownership of the Exxon stock from the name of Michelle to an account in the name of the estate of Michelle. Because before she gives it to the whales, she has to make sure all of my debts and expenses are paid. You've got it. Once she says she's paid my credit card bills, my outstanding medical bills, my funeral bills, if I've had any, then after that, the balance of the funds that are left
goes to the whales.
You've got it. A lot of clients ask, what happens if I don't have a will and I own that Exxon stock? Where does it go? New York State, a lot of clients mistakenly believe, New York State gets the stock. New York State doesn't get the stock.
They have to find someone.
They decide who gets the stock.
Oh.
There's intestacy laws that say when a person in New York State dies without a will, we, New York, are going to decide who gets it. And they say if you're married and have children, your spouse gets about 50% and your children get about 50%. Now, in the day and age that we are in, where there's a lot of second marriages, that may or may not be what the client wants, right?
Exactly. Yeah.
If I don't have a spouse or children or grandchildren, then it goes to my parents if I have any living. Sometimes for younger clients that are in the 50s and, accidentally pass away, now they're leaving money to their parents. And sometimes that's not a good thing, depending on their parents' situation, right?
Yeah.
If they have needs of their own.
Yeah.
So having a will gets you out of that New York State statutory scheme where they're deciding where your assets are going that would have been covered by a will had you had one. Make sense?
Yeah. Yeah.
A little bit?
Yeah.
Yes.
We're talking about a lot of stuff. So
yes.
I'm looking at the time because how much time do I have left?
Well, I have a question.
Don't worry. As long as you're sitting there, we can keep talking.
Okay. What's your question, Denise?
I have a question from one of our people, from Jean, who's watching. She wants to know.
Hi, Jean.
How do you remove deceased spouse from a deed, car, or anything else with his name on, with the deceased name on it?
Okay. So the first thing you need to look at is the actual documentation that governs ownership. So for a house, that's normally a deed. So you have to look at your deed. And if your deed says John and Jean as husband and wife, let's just say, I'm pretending Jean is married to John or was married to John.
Well, she was actually.
That's weird. Well, I'm sorry, Jean. Then if the deed says John and Jean, comma, his wife, then that means when John passed away, Jean automatically inherited that property and owns it 100%. Do you need to do a new deed taking John's name off? Technically, no. If Jean goes to sell the property, the title company for the purchaser is going to request a copy of John's death certificate to verify that Jean is the sole owner, but technically she doesn't have to change the deed. However, I do occasionally have clients who want to change the deed because sometimes they run into issues related to homeowners insurance, right? If your spouse passes away, you have to be cognizant to make sure that you're changing the registration of your homeowner's insurance to be just your name only. Because if there's a claim on the homeowner's insurance and your deceased spouse is still listed as insured under that policy, they are going to issue the check to both of you. And normally to deposit a check, the payees need to be alive and have open accounts. So you can keep the deed the way that is if that's how your deed reads, but you want to make sure you are updating or contacting your homeowner's insurance company to update the insureds. And also you might want to contact some of the utility companies. With respect to the car, that's a whole
another story.
The car works like this. If a person who passes away has only one automobile and that automobile is worth less than $25,000, there is normally a process that the surviving spouse can utilize through the actual Department of Motor Vehicles to transfer the ownership and registration from the deceased spouse to the surviving spouse. However, if the decedent has more than one automobile or motorcycle or whatnot, then in order to change the title of those things, you are usually going to have to do or commence some sort of probate proceeding in surrogate's court. It may be what's known as a small estate administration, which is kind of an expedited process that a lot of clients try and do on their own if the total value of those assets are less than $50,000. But without seeing the documents, it's a little hard for me, or knowing the values, it's a little hard to give a definitive answer.
Mm-hmm.
Good?
Good.
Little bit? Okay. I hope, Jean, that answers your question. At least
Yes.
it gives you a little more information.
Hold on. Let me say hello to Daria Gentil. She was one of our guests, I think 2 weeks ago. Hi, Daria.
Oh, Daria, yes. Daria was a guest a couple of weeks ago.
Yes. Denise,
okay.
you have something?
So can you just talk a little bit quickly about the type of deeds there are?
Okay. Yep,
Let's
absolutely.
go to deeds.
So let's talk about deeds. There are 3 types of deeds. The first deed is called tenants by the entirety. That is a special deed between spouses only. How do you do a tenants by entirety deed? You have to be married when you are taking title to the property. And it's merely something that says, John and Anne, his wife. That is a tenants by the entirety deed. That means when the first spouse passes away, the surviving spouse automatically inherits that property, even if the will says when the husband dies, he's leaving everything to his children from his first marriage, because it says it on the deed. Okay. If you get divorced and you never change the deed, absent the existence of a separation agreement or a divorce judgment that indicates otherwise, that tenants by the entirety is automatically severed, and ex-spouses each own their 50% individually. And if they don't do anything to change their portion of the deed, their 50% will be governed by each of their wills when they die. Separate wills. Okay. The next kind of deed is a deed called joint tenants with rights of survivorship, or the way you can own property. Joint tenants with rights of survivorship is my sister and I own a piece of property together. We each own 50%. Mm-hmm. We say Michelle and her sister as joint tenants with rights of survivorship in the language of the deed. That means if I die, my sister owns it 100% and vice versa. So whichever sister lives the longest
gets the prize. What happened? Can you leave something to your children? No, nobody can.
You can, but you've got to. The third way or form of ownership.
No. But I mean, with the one that you're talking about with your sister, if you have kids or your spouse can't do anything with that because of the type of deed.
You got it, because it's in the deed. So when you're buying property, it's really, or if you own property, it's really important for you to go back and look at that deed to see what it says. I'm going to check my deed. Yeah. The third form of ownership is something called tenants in common. So that's where it's Michelle and my sister. But after it doesn't say it's tenants in common. It just says Michelle, my sister's name is Christy. Michelle and Christy. That means when I die, my 50% is controlled by my will. And if I don't have a will, by the intestacy laws based on who my surviving heirs are. And the same with my sister's 50%. So this is one of the things, believe it or not, that attorneys really don't discuss with clients till they're sitting at a closing table and the clients really aren't making informed decisions.
Exactly.
Right? This is important stuff.
Yeah.
Yes.
Right?
They're just signing papers.
Exactly. Yeah. And saying, what do you mean? And they don't fully understand the legal ramifications of how you're titling your deed.
Mm-hmm.
Okay. And then really quick, Sandra, let's talk about a trust. A trust is really an agreement or a contract between the person who creates it, called the grantor or creator, and usually a trustee or a manager of the trust, which sometimes can be the same individual as the person who created it, sometimes not, depending on the type of trust you are creating. And the trust will say, depending on the type of trust, who has the right to use the assets that have been transferred into the trust while the creator is alive. And that trust will also indicate when the creator dies, any assets that have been transferred into the trust go to these people. So it's sort of like a substitute for a will. And any assets you transfer to the trust are controlled by the trust and avoid probate. The will doesn't control those assets.
Okay.
The hardest thing for people to understand is creating the trust is really only step one. Then you have to fund the trust.
How do you fund the trust?
So how do you fund the trust? Most people will fund a trust with real property. How do they do that? If I create the Michelle Jablonski Revocable Trust and I want to put my house in that trust, I have to do a new deed transferring the property
to
from
the trust.
Michelle Jablonski into the Michelle Jablonski Trust. That deed gets recorded, and now the rest of the world knows that the Michelle Jablonski Revocable Trust, when Michelle dies, will control where this property goes.
Okay. And when is recommended to make a trust
oh
versus
my gosh.
a
we
will?
We can talk for an hour about that, right?
No, but just something quick.
So most people want to avoid a trust. I mean, you want to create a trust sometimes when you want to avoid probate, right?
Okay.
You want to avoid probate when you don't want the cost or expense of doing a probate proceeding. Sometimes when you have real property in multiple jurisdictions in multiple states, because if you have property in New York and Florida and you die and they're in your name only, your executor's going to have to probate your will in New York and Florida. Double the money. If I want to disinherit someone, there's a benefit of having a trust. It makes it harder for that disinherited person to contest the trust than it is to contest a will.
Okay.
And another reason why people do trusts to avoid probate, the other reason is if they're worried about estate taxes and they want to try and minimize estate tax. But right now, if you're a U.S. citizen and the total value of your assets on your date of death are less than $12 million, there's no estate tax that you have to pay. So for most people, not a huge issue. New York State has an estate tax as well, but the estate tax threshold in New York State is about $6 million. It used to be only $1 million. That was a problem.
We don't have to worry about that one either.
No. Most people don't have to worry about that either. But some people do trusts for the purpose of minimizing the estate tax liability. The other reason people normally do trusts is if they have a loved one that has special needs, or a big reason people do trusts, in addition to avoiding probate, estate tax planning, special needs planning, is because they're worried about how to pay for their long-term care in the future, like home care and nursing home care, and they want to try and protect some assets. An irrevocable Medicaid trust is a way to create a trust, transfer your assets to that trust, but still keep some control over that trust, because in order for Medicaid to pay for your long-term care or nursing home care, you have to be poor.
Yes.
Okay.
So you can either give away your assets to your loved ones as an outright gift, which is a little scary, right? Because you have no control.
Yeah, they can do whatever they want. They can kick you out of your house.
Or you can transfer it to a trust and you keep some important rights to be able to still control what's going on, which really means you can change the beneficiaries of that trust. You can change the managers of that trust. So that's how you keep people in line, for lack of a better word.
Yeah. And you get your assets safe somehow.
You got it. You got it.
We have another question.
Sure.
Susan wants to know, as a senior, is it easier when buying a home to put your children on the deed so that when you die, it transfers to them? Does that make sense?
So you can, but you have to be, that's called a life estate deed. Some people, a life estate deed compared to a trust is a little bit of an easier process because it's really just a deed, but you have to be careful. If I own my property in the name of Michelle and I want to add my son on as a joint owner to avoid probate, if I add him on, I am creating two big issues. The first one is if I'm enjoying any property tax exemptions, now that he's on the deed, I may lose them because I am no longer the sole owner, and they may consider his income as part of my income when calculating whether or not I'm entitled to property tax exemptions.
Oh,
yeah.
The other issue is that if I already own the house and I want to add my son on that, there could be capital gains tax issues, right? Because technically when I add my son on that deed, I'm making a gift to him, and he inherits what's known as my basis in the property. And that has to do when you ultimately sell real property, because when you sell real property, if you're selling it while you're alive, in order to get a capital gains tax exclusion, you have to live and own the house 2 out of the 5 years before the sale. And if your child is on the deed and they're not living in the house, now you could be incurring some capital gains tax issues. A life estate deed is a little bit of, like I said, a funky subset. It's a way to give away an asset, but you retain the right to live there. The funky thing about a life estate deed is if you transfer your house to your children, retain the right to live there forever. And I have 3 children and I have a falling out with one of those children. Can I change that deed after the fact? Nope. When I die, my 3 children automatically own that house. 2 of them want to sell it, 1 of them doesn't. Is that going to be a problem?
yes.
Oh, yes.
And the bigger issue is if the house needs to be sold while I am alive, my children will get most of the money from the sale. And if they haven't been using it as their principal residence, they will most likely incur
Taxes.
Capital gains.
And usually the reason why you're giving away your property in that way is because you want to protect your assets if you need long-term care. But when you have a life estate deed, you are still considered the owner of a percentage of that property if it's sold while you are alive. So if I've transferred my deed out 10 years ago and now it's being sold and I get 10% of the sale proceeds, that I took an asset that was fully protected and now I've exposed 10% of the value of the house. If God forbid I need long-term care and want to apply for Medicaid. So it's complicated. It's not an easy one-line response.
Call Michelle.
Yeah. Okay. That was great.
That was.
Lots of good information. I love
What else do we have?
Any other questions, people out there?
People out there.
Oh, Diane's on. Diane, you have a question?
Yeah. Too late, Diane. We're
you always
leaving.
have a question. Diane was our guest last week.
Oh, yeah.
Too late, Diane. We're gone. No questions for you.
All right. Susan says good information.
Good, I'm glad.
So let's share, and let me share in the chat your office phone number.
Okay.
Well, I'll write your name in. And Jablonski, okay.
Diane is saying that
her husband got home late. Okay, Michelle, what's the office number?
It's 631-234-3030.
Okay.
and then you ask for me, and they should connect you with my assistant, Bridget.
Okay.
And then she takes all my calls and sets up times and, for callbacks and appointments and those things.
Is there something
Perfect.
we're missing, Denise?
No, I think that was great.
There's a lot.
Yeah, it's a lot. I know.
Is there something we're missing that you want to add, Michelle?
I mean, I could talk for this for 3 or 4 hours. Everyone's situation is everyone. There is no cookie cutter situation. Everyone really, if this is something they're concerned about or worried about, it's worth their time and effort to seek out the advice of an attorney who specializes in these sorts of areas to make sure what they want to happen or don't want to happen.
Right.
Exactly.
Goes the way they want, because there are so many times where there are unintended consequences, and sometimes it's really unfortunate.
And that to find someone that really explains them, that takes the time to explain, that can answer all their questions, everything, whatever they want to ask, and because sometimes they need
it's
to
not easy.
Yeah.
Explaining it in a way for people to understand it is sometimes a challenge, because this can be complicated stuff.
Yeah, it's not like I'm talking every day.
Right. No,
trust
a lot of
deeds,
and then a lot of people, their experience is very limited, right? Yeah. Because luckily we don't, if life goes the way it should, it's normally you're not getting this kind of experience until something happens to your parents.
Exactly.
But that's 20 or 30 years ago, and there's a lot of things that are different now than they were then. So, yeah.
Yep. Diane says it's very confusing. Yes, it is. That's why you have to seek the help of a professional.
That's why she has no questions today. Denise, where they can find you?
I'm right here. I'm on Facebook, Denise Lanzarone, your local realtor. Instagram, Denise Lanzarone. And I'm on LinkedIn, Denise Lanzarone. And you can find me any of those places. Send me a message. Let me know how you like this. I thought this was wonderful. We've had some really great guests this season, and we appreciate everybody watching.
Michelle, where can they find you? Michelle, where can they find you?
Oh, they can find me at www.davidellaw.com, or they can call the office at 631-234-3030. Reference that they saw this Facebook Live event, and then they'll connect the caller with my assistant, who will give them an idea of how the process works.
Okay. Remember, we have 2 more video episodes from this series of real estate seniors, real estate and services. That's the name. We are live next Wednesday, 7 p.m. in Denise's Facebook page, my Facebook page, and my YouTube channel. You find me as Sandra Roman Real Estate in Instagram, Facebook, whatever, TikTok, everywhere. I'm everywhere. Don't forget to subscribe to my YouTube channel, to like, and leave us your comments. We are working already on our 3rd season.
Right. That's right.
And if you have, any specific topic that you would like to see here, send us an email.
Yeah.
And if you want the information of all our guests, we are leaving a link in the description box, so we can send you that PDF file to your email.
The manual.
I can't say manual.
So next week we're having what'd you say, Diane? I'm going to ask a question, Sandra, since I tuned in late. Okay. Next week we are having a guest on. Her name is Judy Serino, and she is going to talk about senior fraud, which is a big topic. Yes. Big problem with seniors these days. So we're going to hear from her next week. So I hope you all join us then.
And
Diane, did you want to ask a question?
No, we're leaving.
Okay. Sorry.
Well, thank you for
kidding.
having me.
Thank
No,
you so
thank you
much,
for
Michelle.
being here, and we'll see you next week. Adios,
Yes.
amigos.
Bye-bye.
Adios.